शिवाजी महाराज संविधान जाण्याची 12 डब्यांची लोकल थोड्याच वेळात प्लॅटफॉर्म क्रमांक 2 वर येत आहे. 7:58 छत्रपती शिवाजी महाराज संविधान जानेवारी 12 प्लॅटफॉर्म क्रमांक 2 पर आ रही है.
सेमिनार के बजाय कन्वर्सेशन का
हेलो हाँ बोला हेलो हेलो
Very good morning, sir. Sir.
Hello, good morning. Good morning.
Sir, good morning. Good morning, sir.
Good morning. Good morning. Just give me 2 minutes. I'll switch over to the system from mobile.
We are waiting for few participants to join.
Okay, okay, fine.
Pardon, 2 minutes.
Yeah, we'll wait.
Hello. Am I audible to all? तुम सबका अनम्यूट कर दीजिए.
Allow. Yes.
Yes. A very good morning to one and all present here. Respected Anil Variyat sir, respected principal ma'am, Dr. Madhura Kalamkar madam. We are here to actually we are here to start with our panel discussion on the topic intellectual property protection on the changing era. I'll request ma'am to give a welcome speech and we'll start with the program.
Yes, thank you, Rituparna madam. Have all the speakers have joined first?
Ma'am, actually, the speakers will join in their particular slots, ma'am. Dr. Anil Variath sir is here. So we can start and we'll just wait for the other speakers to join in 5-10 minutes.
Okay, no problem.
Yes, yes.
Good morning, Anil sir.
Their particular slots, ma'am. So we can start and
Good morning, madam.
Rituparna madam,
Yes, ma'am.
sir is there?
Yeah, I'm there.
Yes,
Can you hear
ma'am.
me?
Yeah. Good morning, sir.
Good morning, madam.
Okay. So shall I start?
Yeah, madam, I will take 2 minutes to switch over to my system, but you can start. You can start.
Ma'am, please unmute yourself.
Okay.
Yes, thank you.
Thank you. So good morning, everyone. On behalf of Hindi Vidya Prajar Samiti College of Law, I, Dr. Mrs. Madhura Kadamkar, in-charge principal of HPPS College of Law, welcome you all on this online panel discussion on intellectual property protection in the changing era. I welcome Dr. Rajendra Singh sir, President of Hindi Vidya Prajar Samiti, Dr. Usha Mukundan, Director of HPPS Samiti, Dr. Anil Variath sir, Register of MNLU, Mumbai, Professor Gargi Chakraborty, Dharmashastra National Law University, Jabalpur, Dr. Seema Samrani, Assistant Director at SK Somaya College, Somaya, Vidya Vihar University, and Dr. Pankaj Kumar, DPILT IPR Chair Professor, NLUJ Assam, and all my dear students and colleague professors. Regarding IPR, what we have conducted our today's webinar, I will say a few words that the intangible nature of the intellectual assets can make them vulnerable to imitation or abuse by competitors. So while some intellectual assets are subject to the natural protections, recourse to more formal recognition and protection of intellectual property may be needed in order to provide economic incentives for innovation and to enable rights holders to defend their legitimate interest. See, some forms of IPR protection which have been available in some of the countries from centuries ago. Like in US, Constitution ratified 1789 May included a copyright and a patent clause. Since 1880s, international agreements now supplemented and administered by the World Intellectual Property Organization, that is WIPO, which have provided some standardization in the treatment of intellectual property. However, it was the World Trade Organization agreement on these TRIPS, what we call trade-related aspects of the intellectual property rights, that most effectively ensured implementation of minimum standard of protection for intellectual property across most of the world, including developing countries. So while this TRIPS agreement has been in effect since 1995, the implementation in developing countries has rolled out in a manner due in a part to provision of transition periods. So granting in these exclusive rights is a culture of our modern society was born into. However, knowing that it has existed for millennium tells us of our valuation of the individual talents. Although the ancient Greeks still considered their invention as a gift from the good. So recognizing the human part of the innovation process proves that we are very similar to our distant ancestor. Therefore, identifying the defining moments in the history of patents, copyrights, trademarks, and the other protective rights is akin to holding a mirror in front of our society. So this is what we are definitely our today's panel discussion on this particular topic that is in a changing era is going to in a beautiful way with the eminent speakers. So I will hand over now to Rituparna madam to carry on with the other sessions. Thank you all. Thank you.
Thank you so much, ma'am. Before we start, now I will like to introduce Dr. Professor Anil Variath, sir. Sir is holding the charge of a registrar of at the Maharashtra National Law University, Mumbai. He also serves as the director of the Center for Research in Criminal Justice and the chair professor and director of Justice M.L. Pense Chair in Environmental Laws. Before joining Maharashtra National Law University, Mumbai in 2019, he served as a professor, head of the institution, and deputy director at Mumbai University, Amity University's Law School, Mumbai. He has also served as the professor, officer on special duty, and head of the Department of PG Studies at Maharashtra National Law University, Mumbai, and the faculty in charge and coordinator of SNDT Women's University's Law School. He has appeared before the Parliamentary Standing Committee on the Clinical Establishments Registration and Regulation Bill 2007. With over 2 decades in legal profession, he teaches constitutional law, corporate governance, international humanitarian law, comparative public law, and environmental law. He has authored 4 books and have more than 30 articles. He has also supervised and 3 PhD students and who have also been awarded their PhDs. I welcome you, sir. Thank you so much for accepting our invitation for this particular panel discussion. Thank you, sir. Sir? Sir, can you hear me?
Rituparna madam, just wait. Just send a
Yes.
message. There may be some technical problems. Don't worry.
Yes, ma'am.
Sir
Yes.
will join soon.
Yes. We also have Dr. Seema Sambani, ma'am. She has also joined. She will be our second speaker for the day. We welcome you, ma'am, in our panel discussion for today.
Thank you. Thank you, Rituparna.
Thank you so much,
Hello,
ma'am.
Dr. Madhura, madam.
Yes, good morning, madam.
Good morning.
Thank you.
Good
Yeah,
morning.
thank you for accepting our invitation. I hope our students will definitely get some knowledge about the today's topic. Thank you, madam.
So thank you. Thank you for the opportunity. Thanks.
Ma'am, we are just waiting for Sir to join, then we'll start off with the session. Sir has actually joined, but he got disconnected due to some reason.
Mhm.
There is some technical glitch at the end of sir. So he requested me to carry on with the particular panel discussion, and he will join later. So Seema ma'am, if you allow us, then can we start with your session first?
Yeah, okay, no problem.
Okay, ma'am. Okay. Just I'll introduce ma'am for all our participants, and then ma'am will give her talk. Dr. Seema Sambani ma'am serves as an assistant director in S.K. Somaiya College, Somaiya Vidya Vihar University. She heads the Department of Biotechnology, and she is the convener of IPR cell in Somaiya Vidya Vihar University. She has been in the field of higher education and academics for more than 25 years, and has her expertise in building new departments, competence building, industry academia collaborations, and curriculum development. She has been awarded Best Microbiology Teacher Award by the Microbiologist Society of India. She has been the principal investigator for a research project as a women scientist, Department of Science and Technology, Government of India. Dr. Seema ma'am has served as a key contributor in the preparation of the proposal for the establishment of BIRAC, that is Biotechnology Industry Research and Microbiology Society of India Associate at IIM, Ahmedabad. Dr. Seema ma'am has research interest in the field of industrial and environmental microbiology and biotechnology. She has worked extensively in the field of applications of solvent-tolerant microbes and their enzymes. She has 9 research papers, a patent, and a copyright, and 2 textbooks to her credit. She was invited as a speaker at the Global Biotech Congress at Boston to speak on her work on solvent-tolerant. Dr. Seema has participated in more than 40 national and international conferences in the capacity of a presenter. Thank you so much, ma'am. I would request you to start with your session.
Can I share my screen? You have given the rights.
Yes, ma'am. I think you can share. Yes, I have allowed.
It says host has disabled. Once again, I try.
Yes, ma'am.
Okay, I can now. I can.
Okay, thank you.
Is my screen visible?
Yes, ma'am, it is visible.
Yeah. Good morning to one and all. A real good morning, because we have started the session very early. And I take this particular opportunity to thank the management and authorities of Hindi Vidya Prachar Samiti's College of Law for giving me this particular opportunity. So the theme of your panel discussion is intellectual property in the changing era. And here I feel that biotechnology definitely has changed the era, the way biology and technology are looked into. So what I feel is, see, if at all we try to look into the global scenario and Indian scenario, biotechnology is the hub of activities today. So if at all we take the financial year of 2025, there we will find that the biotechnology industry in India will definitely increase to more than $100 billion. It has started from, like, in financial year 2015, it was around $7 billion. But so this particular gap from 7 to 100 in about just 10 years, it shows the importance of biotechnology. So I know that this particular event is being conducted by Law College. And here I feel that I would just like to tell a little bit about biotechnology. So the flow of my presentation will be a little bit on biotechnology, and then what are patents in absolute short, this thing. And then what is it that the global scenario and the Indian scenario in biotechnology and patenting. So this would be the flow. But if I would like to tell you about what is biotechnology, so this biotechnology as such is not new to human beings, because since times immemorial, it has progressed significantly in different forms and uses. Is there any issue? Am I audible?
Yes, yes, ma'am, you're audible.
Yeah. So if at all we look into the simple thing like the production of alcohol by fermentation or isolation of antibiotics from microorganisms, so these are all examples of classical biotechnology. But now this biotechnology has gained several relevations after the invention of the structure of DNA. So from then we started calling it as modern biotechnology. So genetic engineering technologies, methods of producing organisms, isolation of organisms, mutations, transformants, plasmids, monoclonal antibodies, all of these are part
I
of
request all
biotechnology.
the participants to kindly mute themselves. Thank you, ma'am.
Yeah.
Okay.
So what has happened is, since bio means life, so unlike the patents of other areas, whenever we are having anything that deals with life in any form, it is associated with things like morality, public order, environmental protection. And that is the reason getting patents to life forms becomes very, very difficult. So if at all, we just look into the news that has come like from the 1990s, like India wins the Basmati patent case, but the trademark issue remains. Okay, so these were all there in the news. Now, the most Indian famous case studies of the patent of Basmati, the patent on turmeric and patent of neem, that has instigated the whole world against what is it that means by why is it so important to have biotechnological patents. So as you know, with the case of Basmati, which was very of Asia, in Pakistan, India and Bangladesh region, the people in America, they had the same Basmati with another name like Texmati. Turmeric and neem are very Indian, but still these were produced into forms of different products and they were trying to sell it to the whole world. So see here, this is how we have several questions. So now if at all we want to know what are intellectual property rights, most of you are law students, so all of you definitely know that the website of intellectual property rights will give you more about the intellectual property rights. So all of us know that there are two kinds of assets, tangible and intangible. Tangible, that which we can see, feel and touch, and intangible, which we cannot do the same as with the tangible. So whenever we are talking about intellectual property rights, it is for the intangible assets. So the first lecture was to do with the trademarks, but I have started it earlier now. So when we talk about intellectual property, it is patents. It is in the form of patents, designs, trademarks, copyrights, GI, and layout of designs of industrial circuits. So whenever you have any innovation, right? So you have a big question as to how do I protect my innovation? So these are the various directions which you have to decide whether you, whatever you have created by your intellectual usage, whether it reaches which form of the patent, which forms of the intellectual property. Now here, if at all we go into patenting, definitely we should go for it, because money is honey, and if you have a very good patent, definitely you will earn in millions. So I would just tell you like what is a patent. So it is a set of exclusive rights given to the inventor by the state for a fixed period of time. And This is given by the state, meaning that particular country, because patent is for a particular geographical jurisdiction. And it is given for a particular period of time, that is 20 years. So we are given a patent if at all we are disclosing something publicly, and this particular invention is novel, it has an inventive step, and if it is capable of industrial production, we get a patent. So patent helps to prevent others from making, using, and selling the invention. So it is your exclusive right. If you do not want a patent, then this. So all of you might be knowing what is this. So this is a big, big trade secret. But there were instances earlier that if you do not want someone else to copy your work, so we know what happened to the people who constructed this particular beautiful Taj Mahal. But today we cannot do the same because it is not legal. So actually, patents were first designed by Thomas Jefferson in 1790. Why? Because during the industrial revolution which took place in the Western world, people saw that each other competitors were copying each other's work. And hence, in order to protect, he said that we should have something like the patents. Various kinds of patents are there, like the utility patents, the design patents. Otherwise, you have something called as the pioneering patent. That is the first patent that you have applied. You have worked more on it, and then you have given an improvement patent. And finally, you have formed a product out of it. Then you get a product patent. So since we are talking about biotechnology and patenting, so here I would just like to show you a few trademarks which are very well known, like that of the Pfizer, the Monsanto, the Medigene, the Mahiko seeds. So these are the trademarks which are found in biotechnology. Now, again, we do have another type of intellectual property, that is the copyright. So we all know that it is given for the authors of original works. So usually it is for the authors, composers, screenwriters, computer programmers, and it is having a long period of protection as for about 70 years. But why am I showing to you the copyright? Because in biotechnology, here again, we do have copyright, which is given to certain DNA sequences that we have isolated. Again, if at all we have taken some photomicrographs of DNA, then we can get a copyright. In biotechnology, the instruction manuals that we are having, they will have a copyright. So these are some of the instances where I just spoke to you about trademarks in biotechnology, copyrights in biotechnology. Now coming to the main thing, that is patents in biotechnology. So let us learn more about biotechnology and patent filing. So as we do with the filing of a patent, when we want to file a patent, we can make it as a PCT application, a conventional application, and a national application. When we are doing the national application, we can use maybe first a provisional specification, and within 12 months, we can file for a complete specification. So provisional specification does not include the claims, while the complete specification includes the claims. And as we all know, it is for the claims that we get the patent and not for the other written material. I have done something in biotechnology and I want to patent it. Where do I go? So we go to the regional offices. So being in Mumbai, when I want to patent, I go to the Western Region office, that is the Mumbai office. Now, when we talk about the subject matter of patent applications, so whenever we say patents and the biotechnology patents, see, usually the patents are applied for antibodies or antigen binding fragments like the monoclonal and the polyclonal antibodies. Patents are applied in biotechnology for diagnostic kits, tests, diagnostic test, host cells, microorganisms, and stem cell products or processes, for the transgenic cells, for vaccines, right? So all of you recently, you might have seen the COVID vaccine. So pharmaceutical vaccines, there are several vaccines which are there. Then plant and animal tissue culture products and processes, polynucleotides, gene sequences, polypeptides, protein sequences. So in all these cases, either as a product patent or as a process patent. Even for any of the things that are related to the vectors like plasmids, even the products and processes that are there with these vectors, they all can be patented. So since I'm focusing only on biotechnology and patenting. So when we are talking about patents and biotechnology, I told you that it has a very big social impact. So we need to know what is it that is happening in the globe as well as in India. See, what the Indian Patent Office says about biotechnology patentability is the living entities of natural origin and the manufacture and production of these products which are related to, one sec. These products which are related to living entities, they are not patentable. Any method or treatment such as medicinal, surgical, curative, prophylactic, diagnostic, and therapeutic, they are not patentable. Gene sequences and DNA sequences. See, in the beginning, I have told you a list where patents are being applied for the biotechnology patents. But here, when we see gene sequences and DNA sequences without any function, they cannot be patented. Biological processes for the production of plants and animals, no, they cannot be patented. A substance, say for example, which we get just by addition of 2 or more components and then producing a new substance, that does not get a patent. See, if there is a formulation without any synergistic effect, it cannot be patented. Say, for example, we have a biofertilizer formulation, which is comprising of a phosphate solubilizing bacteria and nitrogen fixing bacteria. So in these cases, yes, we can get a patent. Again, if at all we are talking about any method of agriculture or horticulture, we cannot get a patent. See, there are several sections which are there, and these sections, they tell us what cannot be patented. See, most of the cases, what cannot be patented is what is given. Even if you visit the frequently asked questions on the website of the Indian Patent Office, you will get a series of sections which tells us what can be patented and what cannot be patented. If you take the section 3I, so see there they say that plants do not fall in the ambit of the section of medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatments of human beings. See, you cannot have all the patents for yourselves, then how will we serve the society? So this again is a patentability issue. So before I go to the deposition of biological materials, here I would like to talk to you about one particular concept here again. See, I just spoke to you about what cannot be patented in India and what can be patented. But if you just like to take the jurisdictions like the United States of America, Europe, Japan, Australia, and Canada, see, it is seen that Australia is the most lenient in patenting biotechnology, whereas USA again follows the suit, and India is very, very stringent about patenting in biotechnology. See here, a recent report, see, it says that the World Health Organization states that the industrialized nations like the US, Canada, Europe, and Australia currently hold 97% of the biotechnology patents worldwide. See, again, in the field of gene patents, US inventors are filing more international patents on DNA sequences than any other country, combined with all the inventors of USA and Europe. See here, the first USA patent that was granted to recombinant DNA was in 1980, which was shared by Harvard University, University of California, and Stanford University. Till 2013, more than 5,000 patents have been granted in human genes. So you just see that, yes, there are instances where a lot of patenting, like initially till the invention of the DNA, not many patents were granted and not many strict stringent rules were there in granting the patents. But after that, yes, it has changed. When we talk about biotechnology and patenting, one of the important things that we should know is about the Budapest Treaty. In Budapest Treaty, it has been told that if at all you are having any biotechnological invention and it is having some microorganism involved in it, then that microorganism needs to be deposited in a IDA, authority recognized culture collection center. So there we have to deposit, and it is mandatory to deposit before we file. In India, we have MTCC in Chandigarh and Microbial Culture Collection in Pune. So where we can deposit our cultures when we are trying to file a patent in biotechnology. So when we want to file a patent in biotechnology, it has the same processes as the title, abstract, invention, and summary of the invention needs to be given. Patent prior art, patent non-patent prior art, then advantages of the work that you have done over what has been already done in the prior art. So these are some of the specifications that are required when we want to file a patent. So when we want to file a patent, we need to have several forms to be filled. So these mandatory forms are Form 1, 2, 3, 18A and 28. And there are certain optional forms like Form 5, 9 and 26. All these forms and fees are available on the website of Indian Patent Office. So just to show you a few forms, we have the Form 2, Form 3, Form 26. The fees payable schedule is given, and we have to file a patent, and by the time you get the patent, there are a series of processes, and between 18 to 36 months, you can get the patent. So when we are patenting, we need to look into what is it that is going to benefit us by filing, publication, examination, abandonment, continuation in part, or maintenance. So if you want to see how a patent looks like, so this is my own patent. It looks like this. So Indian patents are given both in Hindi and in English. So this is the letter that the Indian Patent Office sends to you once your patent is granted. The US patent looks like this. They all have a barcode, whereas in Indian patents, we have a hologram. So when we are trying to look into the various patents that are there, so they have all been digitalized now and they're available for the general public. So what are patents going to help? It helps you to get money. You can form an industry with that. And that is what is looked forward. So earlier it was said, publish or you will perish. Today we say patent and you will flourish. If you see the analysis of distribution of patents, CSIR labs hold the maximum number of patents compared to the private companies. If you look into the patenting that is being done, so you will see that these are the bioclusters which have filed maximum number of biotechnology patents. If you just have a look at this. See, if at all we have a understanding as to there are several patents that are there and how do we go about managing these patents. So nowadays people are thinking about, you have done some work on BRCA gene, I have done some work on BRCA gene, then why don't we pool the patents? So this is how technology is not attractive if we work in isolation. So that is how we are talking about patent pooling. So I would just like to conclude before I say thank you is, see, the first patent that changed the scenario in the case of biotechnology was with the patent of Dr. Ananda Chakravarti with the Pseudomonas putida, where he had inserted genes in the plasmid which helped in cleaning the oil spills. And Diamond versus Chakravarti was the most talked about thing, because he was not getting a patent, and then Anand Chakravarti said that this is not a natural microbial cell, but I have genetically modified it. So that was a landmark decision which was given. And since then, US says anything under the sun in biotechnology can be patented if there is a human intervention. Onco mouse. So this is another animal after the microorganism which was patented. Because it was animal, still it was patented because it was helpful for the society. So over a period of time, we have seen that yes, there are patent laws. People are going on modifying these patent laws, amending these patent laws, so that everybody gets the best out of these biotechnological patents, and it will be a great help to the society. So I feel that biotechnology and patenting is, of course, a very big topic. But in short, in the given 20 minutes, I have tried to give you an overview of what is biotechnology. Thank you so much.
Thank you so much, ma'am. It has definitely been a very informative session. Thank you so much for, like, in this short duration, you could have give us such a comprehensive presentation for all of us. I will ask our participants if they have any question for ma'am, as ma'am might leave the meeting by 9 o'clock, as she has some commitments. So if any one of you have any kind of question for ma'am, please put it in the chat box, or then I will be reading it out for you. Is there anyone having any question? Okay, so we can move ahead. Thank you so much, ma'am, again for your time. Thank you so much, ma'am. So
thank you for the.
Yes, ma'am.
I will stop sharing.
Yes, ma'am. Yes. So, sir, can you hear us?
Yes.
Okay.
You can also hear me, no?
Yes, sir. Yes, sir. Very well. Thank you. So we will now start with the first slot presentation, that is on copyright protection in the digital era. So Dr. Anil Variyat sir will be enlightening us on the topic. I'll be taking an opportunity to introduce sir once again, as sir was not there at the moment I was introducing him. So once I introduce sir, we can start with the session.
It's okay, no problem. Once introduction is over, it's fine.
Yes, sir. So actually, sir requires no introduction at all. He is holding the position of registrar in MNLU Mumbai, and he is always a supportive and helping hand for all of us. In all the legal fraternity, he is always there to help us in every manner possible. So, sir, I'll request you to kindly start with the session.
Yes. Thank you, Rituparna madam.
Thank you.
Good morning to all. The patrons of the program, Dr. Rajendra Singh, Dr. Usha Mukundan, the principal, Dr. Mathura Kalamkar, Professor Amar Salve, my co-panelist, Dr. Seema Sambarni, Professor Gargi Chakrabarti, Dr. Pankaj Kumar, and all the participants who have joined here today. A warm good morning to you all once again. And my topic, I'm not presenting any slide, and I will try to be as brief as possible. I know that you have the FDP also going on parallelly. So my topic is with respect to the challenges of copyright protection in the digital world. As you are aware, copyright itself is a type of intellectual property that protects the original work of authorship as soon as the author fixes the work in a tangible form of expression. So when you speak about copyright, it's again a bouquet of rights in its third. There are a lot of different works which are subject matter of copyrights. it includes writings, the books, poems, blog, computer programs, then painting, photographs, illustration, musical composition. There is different type of copyrights are involved. Architectural work, then movies, dramas, play, so many things, all visual and performing arts. So what is required to attract the copyrights? Works, I'm just giving an introduction, works which shall be original when they are, that is one of the essential element of pre-condition for attracting the copyright. The copyright must be, the work must be original. So what is originality of rights? Works are said to be original when they are independently created by a human author, and it should have a minimum degree of creativity. So independent creation by a human author means the person should create it by himself without copying anybody. And the Supreme Court has described creative work. What is creative work? Creative work is work that must have a certain spark of creativity. So there are many other things which will be creative in nature, like the titles, names, short phrases, slogans, but they are not subject matters of copyrights. Then another one is that another aspect is work must be fixed, originally fixed, originality and the fixed work. So when you say work is fixed when it is captured either by or under the authority of the author in a sufficiently permanent medium, such as the work can be perceived, it can be reproduced, it can be understood, it can be communicated for more than a short time. So when a work is recorded, then we can say it is also fixed one. And it would be interesting to note that as the previous speaker, Dr. Seema, has already said, protection of intellectual creativity had been a challenge to the legal system right from the modern times of progress of humanity has started. You will find as early as in 1790, the US copyright law has passed. Then we can take that as a starting point of copyright laws in the modern sense in the world. While enacting the law, the US Congress has in unequivocal terms declared that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, of course, there is controversy with respect to the fact whether intellectual rights have to be protected or it has to be thrown open to the benefit of the whole world. It is not the debate is going on for a long time, right? Ever since the beginning of the intellectual property rights. But since most of the world have enacted laws to protect the intellectual property rights and international instruments have been in place for that purpose, let us go by the position which is prevailing in the world, in the other parts of the world itself. So, as you are aware, the most beautiful gift the nature has given or given to the people is technology. The technology has, brought in dramatic changes, revolutionary changes in the human life, and the digitalization had been the most advanced or the recent advancement in the progress of human race across the globe. So digitalization, of course, has brought in with itself a lot of positive changes. However, a wrong use of digital technology also gave rise to a lot of chaos, lot of problems, including crimes. And every development, every discovery, every invention has some or other impact on other aspects of knowledge also. And unfortunately, the digital technology has adversely affected the copyright protection. And copyright protection face a number of challenges with the advent of digital technology. So when we speak about digital copy interaction interface between copyright and digital world, we have to think about copyright and internet, the multimedia work, the copyright, the softwares, and whatever happening in the social media. Now you cannot think of a world, even a day, without social media, without your internet, without your technology, without your iPad, without your mobiles, without your WhatsApp, without your LinkedIn. You cannot think even of a day. So that much people have been involved and attached to the digital world. So internet has been also has been a major threat to the copyright for a long time. See, a large number of information is available on the internet, and the information which we are getting from internet, have you ever thought that, or have you ever understood that the information which you are collecting from the internet also involves varying degrees of copyright violations? Copyright in the internet, see, it is related to so many things. It is related to the ebooks, it is related to the blogs, it is related to the images, it is related to the graphics, stories, screenplays, videos, whatever we get in the internet. It has a lot of copyright aspects. The large ocean of information available in the internet also makes it difficult to determine whether the work is original work or a duplication or a copy of somebody's original work. And again, this problem becomes more aggravated because of the because of belief, or rather I should say it as a myth, that information as available in the internet belong to the public domain and it can be copied freely. See, it is a common belief. Many people genuinely believe, but it is not correct. It is not true. Unless the information has been made available by the government or the term of copyright, because you have seen the Congress, US Congress telling that giving protection to a limited period, because fundamentally the body of knowledge belongs to the public at large. So you cannot tie, or you cannot reserve the domain over the knowledge for long time. You cannot create monopoly or proprietary interest in respect of the body of knowledge for a longer period. But for the purpose of development, the law has been evolved to grant protection to a limited period. So when copyright is also a right which is available to a certain period. So if the copyright period has been expired, or the holder of the copyright, that means the author himself, has surrendered his rights and permitted that it can be used for used by the public, then there is no copyright violation. Otherwise, accessing internet itself involves a lot of copyright violations. So when you say infringement of copyrights in the digital world, it includes It starts with downloading and uploading. See, through digital media, a large amount of downloading of softwares and files takes place, which include or which involves making copies or reproducing the copy of material already available in the internet. But there are a number of restrictions which have been compiled or which has to be complied with the user of the digital media, and the failure to comply with these restrictions or limitations will result in copyright violation, which itself is an offense. See, for example, if 2 or more programs are compiled to create another work, see, which many of us, I don't say you, many of us do, copy paste and create a new something. It's nothing but a compilation of 2 or more works. Then the product is called the derivative work. See, this itself is an infringement or violation of copyrights. See, whenever you write a research paper, whenever you write a article, lot of compilation of this type takes place without proper authority. So there itself we are doing violation of copyrights in the digital media. Another instance is where an image is displayed on a website by linking it to a website and host the image in the websites. So such linking can also result in violation of copyrights, which is known as technically known as hot linking. Again, copying a video or an audio file and reproducing something, just like in the case of derivative work, that also amounts to copyright violations. See, these violations are happening either knowingly or unknowingly. Many of the time it happens unknowingly or without understanding the seriousness of that. Then again, when you speak about the multimedia, work in the multimedia, even the term multimedia itself is so wide, and it encompasses in itself a large number of material, including the text, the sound, the audio, the videos, the images, the graphics. And you must understand that all these things have its own copyrights. The copyright protection is available in the multimedia under the literary category, artistic category. When we speak about literary, it may be the software system, artistic related to images, and with respect to films and videos, there are cinematographic rights. There may be copyrights related to plays, dramas, then musical works, lot of sound recording. See, when it comes to a musical work, different types of copyrights are involved. It may be related to the sound recording, may be related to the tune, may be related to the lyrics. Then, photographs which you see in the internet. So protection of the rights of these creators or the owners of the creations, it becomes very difficult in the digital world due to the variety of rights which are available in the ambit of copyright and vulnerability of these rights in the digital media. So when you speak about infringement of rights in the multimedia, what all it include? See, copying of work of a creator without his permission. disturbing multimedia product other for any purpose other than educational purposes. That disturbance may include the form of downloading, taking prints, distributing. If any commercial angle is involved or any other angle is involved other than the educational purpose, it results in violation of copyright. Taking print of the literary material or artistic work without the permission of the owner of the copyright. Next is dubbing and selling, remixing through any multimedia product or any sound recording without proper permission of the creator. All these things result in violation of copyright in the multimedia. Similarly, you might have heard or you are very much aware about the concept of software piracy. Software piracy includes creating a copy for any purpose other than educational purpose and selling it. Even for educational purpose, selling involves a copyright piracy, because then is creating a copy and exporting the copy of the software. Another is renting the software without proper permission. Selling computer hardware, machines. See, this is all very common, which happens. I don't know. Sometimes we may not notice, or sometimes we ignore the legal aspects. Selling of a computer software machine with a pre-installed or pre-loaded pirated version of software. Copying of software programs using SCD. Now I am telling, see, we are all using computers. Many programs have been installed in your computer. You make a self-assessment. How many of you are using pirated versions of software? How many of you are using pirated software? And how many of your software which are installed in a computer are genuinely licensed products? So, software piracy is one of the major areas involving copyright infringement, and it itself is a challenge to copyright protection in the digital world, because these things are very difficult to understand. So you take even the Bombay city itself. In Mumbai, there are lakhs of computers, and it is not possible, humanly possible, to inspect the computer and find out who are all using pirated software, because that use itself it becomes a crime. The moment you sell your computer to somebody, you are selling the hardware wherein a pre-loaded, pre-installed pirated software is there. Maximum what the law enforcing agencies can do is that those who are involved in the selling may be checked or some may be caught, but that is also comes to a very less percentage of the total volume of violations and infringements is compared. Another, see, social media has become part and parcel of our life. And nowadays, the social media platforms have become one of the most important mode of connecting people across the globe. Your WhatsApps, your SMS, your all other Instagrams, all these are the platforms which gets you connected to other people. So through this platform, a lot of words are shared. Lot of things have been shared. See, right from your good morning messages see, there will be lot many messages, stories, short stories, interesting materials are shared. Many a time, whatever is being shared by you and received by you are copyright infringements, are instances of copyright infringements. Widespread practice of sharing materials such as images, photographs through social media has resulted in gross infringement of copyrights, which the law is not capable of checking. Another problem related to the social media, improper use of social media, which may even aggravate at a little level higher to illegal use of social media, is that there is again a misconception, a notion, a false notion among the people that whatever material is posted in the social media is free because it is in the public domain. It is not like that. And people feel that they are ignorant about the presence of copyrights in such materials. And the ignorance of the people itself is one of the reasons for copyright infringement in the social media. So posting, reposting, saving and sharing of copyright protected works amount to copyright violation in the social media. Reposting and claiming ownership or creation rights in respect of an already protected work, then using the content available in one platform without the owner's prior permission for recreation, for reproduction, reposting, it also involves violation of copyrights. Then another aspect is that the other side, the copyright law always try to protect the right of the creator of the work, but you as a public, as a member of public, or the public at large, also have a public right to have the benefit of certain intellectual creations by somebody else. So here comes a conflict between the private right of the creator of the work in the form of copyright work and the public right of the public at large to have the benefit of the creation. Therefore, the law has to take a point or a stand which will harmonize both these rights. There must be a striking point of balance wherein the owner's copyright is in conformity with the larger rights of the public. Therefore, certain exceptions have been given with respect to the copyrights in the form of fair dealing or fair purpose, because different jurisdictions use different terminology. And it is again, the principle is that human rights of a person should not be used to curtail the rights of another person. The most important convention dealing with the domain of copyright is the Berne Convention. According to the Berne Convention, it shall be the matter of legislation of every country to permit the reproduction of work which is already copyrighted in certain cases, provided such reproduction does not conflict with the normal exploitation of the work and does not legitimate the interest of the author. So this is the point at which the member states have to strike a balance between the rights of the public as well as the rights of the copyright holder. Similarly, the TRIPS also says that members shall confine limitations or exceptions to exclusive rights to certain special cases which do not conflict with the normal exploitation of the work and do not unreasonably prejudice the legitimate interest of the right holder. So the legitimate interest of the right holder and normal exploitation of the work has to be balanced. Therefore, different countries, different jurisdictions have different laws with respect to copyright protection, and in all these copyright laws, exceptions have been given for the fair use or fair dealing of copyrights by third persons. That you will find in the Indian Copyrights Act under section 52. So there are certain things, certain use by of this information or this knowledge, which the law has exempted from the purview of violation. So which also applies to the digital world. I will just summarize certain act which will not be considered as infringement of copyright in the digital world, which would also give you certain relief. One is conducting research or study and making copies of any material available in the internet, even though it is copyrighted, for the sole purpose of study. Understand? Suppose there is a copyrighted material available in the internet and you make a copy of the same in any form, maybe in the print form or in the soft form. But if it is only for the purpose of study or research, it is not a copyright violation. Another thing, a teacher making use of a content from a film to make certain points clear in the class. Though the teacher is using a copyrighted material, which is a part of the film, the teacher will not be liable for copyright violation. Another thing, you find a lot of journals and books, materials in the internet, and you access it through an authorized medium. For example, the university website or university library resource, then it is not a copyright violation. Then making backup copies on hard drive. It will not amount to copyright violation if such backup is intended as a protection against loss or destruction or damage, but it should be for a temporary period. Then it is not the violation of copyrights. Next is observation, study, or test of functioning of a computer program in order to determine the ideas and principles which are underlying the program, and only for the purpose of determining the ideas or principles that are necessary for the functioning of the computer program. You understand and determine, fine. But the moment you start copying it and making further programs based on that, or duplicating the programs, it will go into violation. Similarly, if you copy or adapt a computer program from a personally legally occupied copies, it should result in copyright violation. But if it is exclusively for a non-commercial purpose, it will be protected, and it will not be it will not amount to a copyright violation. But the moment commercial purpose comes into, it will be a copyright violation. Then very simple thing, using CDs, DVDs, pen drive, or any other device of multimedia for playing songs in an enclosed room. Understand? In an enclosed room or an enclosed hall meant for a common use of residents in a particular residential society, residential premises, or any part of the club activity, or in the college or in the school or any association. If it is for a non-profit purpose, there is no violation. Otherwise, even playing a song or a music or even some material through a pen drive or CD, it will amount to copyright violation. The only exception is it should be, if it is played in an enclosed room or hall meant for common use in a residential society or a club, school, college, and not provided is not for profit purpose. If it is for non-profitable purpose, then the copyright violation will not come. Otherwise, it is a violation of copyright. Next is suppose a publication of any speech made by a speaker, delivered by the speaker in public, If you are publishing it, there is no copyright involved. But otherwise, if that is not intended for public, if it is intended for private circulation, if it is intended for a particular class, then it is violation of copyright. See, there are many public online media which are imparting lectures. You will find in the internet. Unless it is permitted to be used by the public, even use of it will amount to copyright violation, because it involves a commercial angle, commercial purpose. Then reproduction or publication of any electronic report of any committee or any other body, any act of parliament or legislature, parliamentary committees, state government, central government, the municipalities, all these things, because they have no copyright protection. But the moment you make the copies with that and it is sold and a commercial benefit is derived, then it will go to violation of copyright. So, so now you understand how delicate the issue is, how things can be, things can become a violation or infringement, and how it can be used in for the purpose of fair use. So now I will just conclude by how only raising one of my point is that how to deal with it. The Copyright Act itself gives protection, but the infringement of copyrights in the digital world has given rise to new challenges, which requires new areas, new devices of preventive mechanisms, and also new approach to punitive mechanism. Another thing is that the investigating mechanism, machinery, including the police, they have to be sensitized with this, because many people, including the police, the lawyers, even the judiciary, are not aware about the seriousness and the scope of copyright, and especially the copyright in the digital world. So the challenges is very, very high, but the resources to contain the challenges is very limited. So that itself is a challenge. It cannot be addressed purely with law. It has to be addressed with the proper awareness and proper sensitization. So with this, I would like to once again thank the HVPS Law College and its management for giving me an opportunity to be with you in this morning, and wish all the success for the organizers in this program ahead. Thank you very much. Thanks a lot.
Thank you, sir. Sir, there are few questions in the chat box, but as we have some constraints of time, so I'll be reading out to you only one question.
Yeah.
So yes, Khushi Agarwal has asked, sir, do you think there is any greater risk for an author to protect his work online than it is in the physical form? If yes, why so, sir?
The risk is always there, but in the digital area, digital field, risk is very wide because of obvious reasons. Because you cannot have, you do not have a mechanism to even to realize who are all copying you, how the violation takes place. Yeah, but there are, see, now the programs have been see, the science and technology has taken its role, and they are coming up with more protective mechanisms. So risk is always there. Okay.
Thank you so much, sir.
Thank you.
Thank you for explaining the concept in such a lucid manner for our students. We'll now move ahead with our next speaker for the day, and resource person, Dr. Professor Gargi Chakraborty, ma'am. Ma'am, are you there?
Yes.
Ma'am, am I audible to you?
Yes, yes. Yeah. I mean,
Okay,
I have
okay.
just taken time to unmute myself. Yeah.
Okay, okay, ma'am. Yes. So, before ma'am starts with her session, I will just like to introduce Gari Chakraborty ma'am to for all our participants. So, first and foremost, welcome you, ma'am. Thank you for accepting the invitation. So, ma'am is currently working as an associate professor in Dharma Shastra National Law University, Jabalpur. Prior to this, she has served as an associate professor in NLU Jodhpur for last 4 years. She has done her PhD from Nalsar University of Law, Hyderabad. MPhil from National School of India, Bangalore, completed LLM in International and Comparative Intellectual Property Law from London Metropolitan University, London, UK, and have previously completed her BSc LLB from University of Calcutta, India. In the year 2020, ma'am was engaged in postdoctoral research fellowship at Max Planck Institute of Innovative and Competition for 1 year. She has excellent knowledge, teaching, and research experience in intellectual property law. Her teaching and research areas are competition law, cyber law, and environmental law. Before ma'am starts, I will also say that she has been my professor and I am her blessed student actually. I feel very blessed to be her student. She has been a guiding light for me all throughout. So thank you, ma'am. Thank you for accepting.
Thank you so much. I'm also proud teacher of you because whatever you have learned, you are disseminating that knowledge, you are updating yourself and you are disseminating that knowledge to your student as well. Thank you so much for the kind introduction. My topic is today the trademark in the physical world and as well as the problem with the digital world. Now, in a very fast instance, I just want to clarify 3 terminology. Okay. I usually start trademark classes even with that particular thing because there is some misconception and interchangeably we use all 3 terminology without understanding there is a difference between. So trade name, trademark, and brand. And interestingly, our Trademark Act, long before, it mentioned that brand can be trademarked. So somehow this concept, we need to clear it up. Now, trade name, Paris Convention under Article 8, it has been clarified that under the name any business entity doing business, okay, somehow TRIPS is totally silent about that particular terminology, trade name. So the thing is like that, any business entity, I mean MNC or any company or startup or anyone. Now Tata Consultancy can be the trade name, or Indian Tobacco Company can be the trade name, or can be the trademark, because the legal regime is totally different. For the business entity name, we are registering name under Company Act or something else. But for the trademark, the law is different and it is having a different impact, and a different legal regime is actually commanding that. So trademark is nothing but a sign. It can be anything because the horizon of trademark is expanding day by day. And I used to say that 2T is very, very, aggressive intellectual property law. One is trademark because it is in perpetuity. Every 10 years, you just need to renew it. And if you can protect your trade secret, it is also in perpetuity, no need of anything, as such procedural thing, just need to keep it secret. Anyway, now trademark sign, it can be a word like Nokia, It can be a color like Krishna Louboutin red color soul, or Nivea blue color, or Tiffany cyan color in this manner. It can be a sound like Intel Inside, you know the sound, or Nokia connecting people, the sound, or MGM lion roaring. It can be a slogan, because slogan we are not considering under the copyright, because de minimis rule apply, because it is so trivial in nature. We cannot consider it under the copyright regime as a literary subject matter. So I am loving it. Just do it. For Nike, all these slogans are coming under the trademark. It can be a sound, as I told. Again, it is not considered as a musical work. It's for just 30 seconds. And now, more or less, every possible country accepted that 30-second MP3 file you need to submit. Previously, the graphical representation, the notation and all those things was required, but eventually now every possible country come down to that particular thing, including India, as per our 2017 rule. Now, apart from that, we have a motion mark like Lamborghini card, door opening, upwards door opening, or 20th Century Fox, that floodlight movement, all this motion mark is there. So there are so many. I mean, each and every day we are expanding the horizon. Now trade dress even came up into the radar. I am coming to that. So trademark is a nothing but a sign. It can be any type of sign which can help us to distinguish one product from other, correct, or service from other. Now I am entering into the shoe shop and I am having in my mind that I am going to purchase Nike shoe. So I am discarding Adidas, I am discarding Fila, I am discarding Lotto, and I am picking Nike by seeing that shoes sign, which we can say the right sign, and just do it by seeing that. So the sign is the identification of source, which is helping the consumer from differentiating one product or service from the other. So under trademark, we are covering the product industry as well as the service industry. This is the trademark. Now, what is called brand? Brand is a much more larger understanding. It's a greater understanding. Now, brand, creating a brand, it's not a matter of joke. So how long you are in the market, how you are connecting with the customer, the consistency of the quality, good lot of things, how you are improving your products or services, and with the time, how you are retaining in the market. And so good lot of things are related with the brand. Of course, valuing the brand. And so trademark is just the one component of the brand. So design, other intellectual property aspect also coming under the brand. So brand is a much more holistic, much more greater understanding than the trademark. Of course, trademark is part of it. And why we interchangeably use brand and trademark? Because end of the day, we are somehow recognizing also brand through that trademark. That is why we interchangeably use these two words. But trademark is nothing but a sign through which, and the legal regime is totally different than the trade name. Just now I have clarified. So now onwards, trademark, trade name and brand, they are the different word for us. They are not interchangeably going to be used, correct? Okay. So this is the first and foremost thing I just need to clarify, because books and articles are not really emphasizing on that particular point, and we have some okay, I'm coming to that how the trademark infringement is happening in the digital market. I'm coming to that. Let's clarify that. This is very important. Maybe you didn't know earlier this three difference. Now coming to the digital world. Digital world, See, the thing is like that. Domain name as such, the registration is a different forum again. Under the ICANN, we registered the domain name. But again, that if the Lee Cooper is selling jeans and or shoes, and Lee is also selling jeans, so both can have the name lee.com. Or Oriental Fan is selling fan, and Oriental Longman, the publisher, is selling the books. Both can have the orient.com, correct? So this can be the problematic situation. Maybe they are already registered under the trademark. Okay, now having the domain name in today's digital world, because we are very keen to know, because every possible mobile is having internet and we start Googling it or searching, internet searching, and we can have that. So in a same manner, whenever we are applying for the trademark, there is a trademark search primarily. That trademark office always figure it out for the similar or same classified classification of goods and services should not be or must not be registered already. Then they always advise the applicant to correct it. In a same manner, for the domain name also, there is a search. Now, if it is already registered, then there is a problem. Correct. Not only that, knowingly and unknowingly, sometimes we go ahead with this type of problem. Though it's a very centralized ICANN, each and every country is having their domain. We know that in.de, .pk, .uk, so these are the there. So top level domain name .com, .org, .bees, all these things are there, and country specific top level domain name is also there. But there is a malintention also. What they usually do, some people, they somehow survey it or work out well. They take the domain name registration and they are not doing any business. So they are sitting on it. And whenever any bona fide trademark holder want to have the domain name, they simply negotiate with lump sum money. It is called cyber squatting. This is nothing but a cyber crime as well. So this is the one prominent problem. But we know that we have two forums to mitigate that. One, any country specific, as per the base of cause of action, they can go to the district court and go on with the infringement suit for the domain name. And another one is the WIPO handled domain name dispute resolution forum is there. It's a ADR. It is not restricted to the member state. It is open for the private party, but they do it under the mostly applying the ADR mechanism. This is the another forum. Now, any business entity can choose their own court or to go for the litigation, or they can directly approach to the WIPO for this domain name resolution policy. So in this manner, they can do that. But it's my personal view that that WIPO handled this ADR mechanism. It's quite fast. And not only that, the criteria to judge the domain name infringement is very meticulous. That's the point. Now, recently there was a case that Kajaria Tiles, we know that, okay? So there are fake domain name and they open for the dealership even. So they have registered the dealers, taken the money, and in this manner, they also through that selling the fake tiles, okay? Then of course, there is a takedown of that particular domain name and the Delhi High Court dealt with that. So in this manner, there are several problems usually happen. Now coming to the other aspect of the our problematic situation. Now the thing is like that. See, the all client-based industry, the biggest asset for the internet industry is the user, correct? So depending on the amount of understanding, the user actually, they fall in the trap, okay, in various kinds of cyber crimes as well. And of course, the trademark infringement. Now, what they actually do, that meta tagging, linking, framing, these are the shadows which allow the user without revealing the identity. And somehow this is creating the digital trademark problem in this manner. Now I'm coming to the one after another understanding also. Just I have mentioned the terminology here. Now link is a set of command in hypertext markup language, HTML language, and when it is actuated by your clicking, right click of your mouse, I mean in your laptop pad or whatever, just on a tap, directs you the browser to the another page, correct? The new page could be in the website you are viewing, or it could be a page in another website. Okay, so well-known type of links are intra-page, intra-system, intra-system, intra-page. Links connect different parts of the same document. Okay, I'm giving the example. A long document, okay, may have a link at the end which takes the user back to the beginning. That is, intra-system links connect different documents on the same server. An intra-system link on the university server might connect the home page of two different departments. Okay, an intra-system link connects documents on different servers. Thus, a document concerning intellectual property law on a university server might be connected to the home page of the government patent office. Okay, so just the example I'm telling you guys how it is happening. Now the thing is like that, we have some cases also. I'm coming to the cases as well. So in this manner, one case, not Indian case, but other cases like Shetland Times Limited versus Jonathan Wilson, other, where the linking case. So the issue present in the Shetland Times was whether a Shetland News dip link to the embedded page to the Shetland Times website or something, which is actually, now here what happened, that we know that whenever we are serving the browse, good lot of advertisements are coming. Now, it is very much confusing for the customer also several times, and sometimes the advertisement coming in such a manner, if you have not a very good knowledge about it or not a control over your tapping or clicking the thing, it's pushing you to open that particular page, and what sort of correct information they are giving, we are not that much expertise to judge that. So it's a push advertisement and they are giving you to open something else. So the thing is like that, the website, maybe trivago.com, is giving the some resort or hotel business and continuously flushing other thing also. Or I'm looking for movers and packers, and other movers and packers links are there. Or you are taking a flight ticket from any portal, Eastrip or Make My Trip. So something, I mean, no best, I mean, very cheap air ticket is flushing that. So in this manner, there is a linking thing, and it is opening the browser and we are fall for it. Okay, we have one case of in this manner, the keyword, even the Google search keyword is having such cases, but it is quite different than the hyperlink, what I am using that. So these are the cases of the hyperlink in this manner. Now, apart from hyperlink, framing is a method of splitting one window into two or more screen. So web page can be inserted into a frame and the portion of the screen will remain static as a user move through other web pages, and this method called framing. Just now I have told about that. Sometime you try your best to through your mobile or laptop to just close, the close sign is coming, the cross sign is coming, and you are trying to close it, but it is not closing at all. It is very static in nature and it is pushing you to open that particular thing. This is the another way. This is called framing. Okay, it allows a webmaster to send an individual through the numerous web pages while retaining the appearance and the utility of the frame inserted. So it is also a, of course, the IP violation, and as well as some are having a good interface with the cyber law as well. Okay, so the pages in the technical perimeter have been sent to open outside of the frame. It must be technically explained. A framing process works. The frames may contain either highlighted URL address or other web pages that intend to be selected by the framing page user or other page within the same website. So in this manner, the framing thing is there. So it is somehow, this concept is not that much illegal in the manner. Okay, but it is creating the confusion to the consumer and violating trademark law, that is evident, and particularly it is creating the unfair competition. Okay, just one sentence I am clarifying here, that unfair competition is always come from the third party. Anti-competition and unfair competition, again, two are different terminology. Unfair competition, when any third party is giving the trying to get the undue advantage on someone else's intellectual property rights, then it is called unfair competition. It is coming from the third party. Anti-competition always come from the holder itself. It's an abusive behavior by the intellectual property holder. So again, this two terminology is different. Don't confuse with that. Now, the unfair competition is elaborately mentioned in the Paris Convention. TRIPS in a piecemeal mentioned about that. But the concept is there in India as well, though in the trademark cases, sometimes we use the terminology and unfair advantage, but as such, the unfair competition is not a very well practiced word or not a very well practiced understanding in India, but conceptually it is very much present, not maybe the terminology itself. So Article 10 bis of the Paris Convention is elaborately mentioned about that. In case of TRIPS, we have Article 22, we have Article 39. In this manner, we have in a piecemeal unfair competition understanding. Okay, then meta tagging. Every domain name can be translated to any IP address, and there is no logical connection between an individually selected domain name and IP address. So we know that domain name, that it is nothing but an IP address. It is actually a number. We know sometimes our universities or very specific page, instead of the page, they given us the number to enter into the portal. Suppose I'm just giving you the example 172.18.0.8.8. In this type of thing is also there, and as well as, so it's a IP address. Okay, so that's there. The value of a simple and memorable domain name is really good for, I mean, it is really important for the business, and has no doubt. And on top of, we are accustomed with the goods and services, and we remember specifically on the trademark actually. So we start looking for the thing online based on that. And from the business entity also, it is quite viable and it is quite, understandable. They always try to have the domain name in connection with the trademark. So there is a trademark infringement is always coming in this manner. So what happened? Very often, customer who is unsure about the domain name will often guess that the domain name is also the company's name. We know the age-old case. Okay, it's a landmark case in India, but again, it's worth to mention here. Yahoo.com was there. Then there was available of yahoo.co.in, and simultaneously there was a availability of yahoo.in. Now, whoever primarily had an email address in yahoo.com, whenever they have seen these two options are also available, obviously they are feeling that yahoo.co.in and yahoo.in both are coming from the source of Yahoo, correct? And they started registering under that because maybe they like to have the email address with that particular top level domain name. Then we figure it out that .co.in was not at all coming from the Yahoo. Yahoo versus Akash Arora is a landmark case in India, one of the very primary case for the domain name infringement. So in this manner, if the customer is not very much sure about that, it can go to the something fake or which is not actually coming from that particular source. We are actually landing in a wrong website, and which is actually the domain name infringement, and as well as, of course, the trademark infringement. In this manner, there are. So this is the one thing. Of course, the trademark infringement is happening. Now I'm coming to the
Ma'am, I'm very sorry to interrupt. Ma'am, I'll request you to kindly conclude in 5 minutes, as there is little bit time constraint.
Yeah, so I'm just concluding it. Sorry, I have not seen the time.
No, thank you.
Sorry,
ma'am.
extremely sorry. So recently we have seen that the ad word, correct? Now we have one landmark case, Bharat Matrimony. So we know that whenever we are searching through the Google search, there are certain advertisement. I don't know if you guys look into it in a very closely. There is a AD word is there. So they are the advertised thing. For coming in the top searching, they are actually paying to Google to do that. Okay. Now the thing is like that. If someone is bona fide but not paying for the advertisement, the search result is not showing them. Now, matrimony is the common word, correct? Shadi is the common word, but it is not going whatever you are looking for, Bharat Matrimony, but it is actually because of the matrimony word, it is ending you somewhere else. In this manner, recently we have a case of Agarwal Movers and Packers. That is the case against the Google, and this is the another case of the ad word with the Google. In both the cases, the using the ad word in this manner and giving the undue preference to the ad word holder, not to the bona fide, and they're losing the customer in this manner. So I'm just concluding it. Today we have a very vast trademark aspect in the physical world as well. Though trade dress we are not protecting as such, but it's very important. US is having that because today Apple Shop is having the trade dress. Ferrero Rocher chocolate box is having the trade dress, which you can connect very easily. So it's a total get up, how it is looking. So different components are there. Not a very specific one sign is only included here. So trademark is a very important thing in just in a concluding word, that each and every day I usually say without IP you cannot breathe, because your mobile is having a number of intellectual property rights. And not only that, our day-to-day life is actually, we are surrounded by a different types of products and services. So whenever we must know that what is the actual trademark, and today's in digital world as well, we have to be cautious. We have to go to the actual website of the company. We need to see the color and contour of that particular logo, or how the word is mentioning there, and accordingly we need to behave. Don't trap on something else which can take your money and create confusion and tarnishing someone else's reputation and giving you something fake. Thank you so much. Any question?
Thank you so much, ma'am. Is there any question? I think the only question that was there has already been clarified by ma'am in her total session. So is there any more question? Thank you so much, ma'am. It is always pleasure to hear you, and I hope that all the participants have enjoyed thoroughly your session. So thank you, ma'am.
Okay.
So we can move ahead with our next resource person for the day, Dr. Pankaj Kumar, sir. Sir, can you hear me?
Yes.
Thank you, sir. So Dr. Pankaj Kumar, sir, is a DPIIT IPR Chair Professor at National Law University and Judicial Academy, Assam. He is a registered patent agent and design agent. He is also an advocate, a trademark attorney, and IP facilitator. He is an AICTE IPR ambassador and an IPR trainer. He has earned degrees of PhD in biotech with special emphasis on patent. He is a master's in biotechnology, master's in law. He has association in information science, specialized in patent information system, equivalent patent information system. He has also done PG diploma in IPR. Presently, he is working as DPIIT IPR chair at NLJ Assam. He has working experience in IPR since 2005. So far, he has served by filing more than 300 applications, including 4 IPR, that is patent, industrial design, trademark, and designs. He has served as a resource person in many IPR programs as an expert. Thank you so much, sir. Thank you for accepting our invitation. You can start with your presentation. Thank you. I hope all of you can view the screen.
Thank you, ma'am. And thank you for invitation here. And generally we discuss in IPR, patent, design, trademark, copyright, etc. It's great to note that you are preferring traditional knowledge in the field of IPR also. So although traditional knowledge as such is not considered for intellectual property right, because there is an issue of novelty, it's not considered novel, and that's why it's very difficult to get protect. So there are huge prospecting here, particularly if we talk about bioresource and the associated traditional knowledge, their medicinal knowledge. There are so many bioresources which the traditional societies know the properties of such resources, and see the raw material, the value of raw material, the cost of raw material, and the final product we access from the market, the end user paying for such bioresources and the traditional knowledge associated with such resources. So there is a huge gap, and who are the beneficiary of all such monetization? Mostly these are the commercial entities. There is hardly any benefit sharing with the stakeholder, particularly the tribes and indigenous societies. So we see there are so many products in the market. All such products in this skin not based on some bioresources, and the knowledge is not new. and that's why none of such products are patented. But whatever the benefit the companies earn, they hardly prefer to share such benefit with the local societies, the indigenous people. See, over harvesting turn Himalayan Viagra into a vulnerable species. The cost is around 10 lakh per kg. So there is a huge value in international market, but again, the problem is who are maintaining such bioresource and traditional knowledge generation to generation, they hardly get any sharing in the profit. So in view of huge commercial value, traditional knowledge and the associated resources, time and again, it's reported numerous entities have misappropriated the traditional knowledge. So during the past few decades, there is a link between bioresource and such traditional knowledge with the IPR. So responsibility of media play a very significant role to sensitize people. And there are some norms like prior informed consent, access and benefit sharing, which must be well implemented in the interest of indigenous societies. So TK, if utilized properly, it may change economic scenario of the country, but it's very difficult to get patent, and that's why there is hardly much motivation among the researchers to do some value addition and research based on the efficacy of the herbal medicines. So there is an urgent need to amend patent laws with pragmatic promotional policies. So generally it's a oral and rural in nature and generated within the communities. It's a very location and cultural specific. So we see there are various bioresources and there are different form of use and they are applied for various purposes. These are some of the tribes. They know what organism can be applied for what kind of issues. So many times we note whatever the indigenous use of some bioresources are tried to get claimed under the patent system. So these are some of the examples we can see whatever the indigenous use of such plant and other bioresources which are tried to get claimed under the patent. So these are quite similar, whatever is already known and what is applied for patent. So there are ample examples. So these are the related issues relates to traditional knowledge. There is a huge prospecting and that's why there is a piracy and people try to misappropriate by means of patenting too. See, this is one of the example where melon is tried to claim under the patent system to cure vitiligo, while it is already the part of our Indian culture, Indian traditional knowledge. Similarly, in the case of lotus, भारत में 5वीं शताब्दी से दिल के आयुर्वेदिक उपचार में इस्तेमाल होती है कमल से बनी दवाइयाँ. So based on such prior arts and codified knowledge, we fight by means of opposition and rectification of such patent application and granted patents and successfully revoked. So ginger used for burn fat, Brahmi ashwagandha. So India filed China biopiracy bid for Pudina kalam mega for cure bird flu. So India wins patent war on hair loss formula. So for such formulation, there is a formulation of turmeric, pine bark, green tea. So UK-based company Pangea Laboratories filed patent application and TKDL opposed this application successfully. So this is quite unethical business practice where there is hardly any prior informed consent with the concerned people, particularly the societies, indigenous societies, and there is no any access and benefit sharing. That's why we say this is unfair business practice. So invention to fulfill certain criteria to get patent, and this is already discussed by one of the resource person here, that is novelty, inventiveness, and utility. So these are the criteria. So mostly such application objected based on such sections like the source and geographical origin of biomaterial and such traditional knowledge is not disclosed, and there is no any technical advancement in view of the prior art, that is traditional knowledge, or the claim doesn't define a new substance like a may be considered a new form of known substance, but substance is known, and that's why it is excluded under section 3D. And under section 3, it's not clear synergistic and comparative data of this claimed composition. So these are some of the objections generally raised in such applications. So such oppositions are very expensive because it needs a lot of time and efforts. APIDA earlier spent around 7 crore rupees to fight case against the basmati rice case. So we need certain source so that we can use that resource to get successfully revocation and opposition of such patent. And we have developed one traditional knowledge digital library by CSIR. So India is the first country which have developed such a long awaited database, and it's get recognition worldwide. And WIPO in fact suggests other member countries to frame such kind of database so that such database can be merged later in order to stop regulate misappropriation worldwide of such bioresources and traditional knowledge. So traditional knowledge digital database is a data.
I request the participants to kindly mute themselves.
Patent office worldwide, like European Patent Office, US Patent Office, Indian Patent Office, Canada Patent Office, etc. Cases of such patent applications based on bioresources and traditional knowledge, and many times in news, such applications are highlighted, and see, these are all such applications which are already revoked or withdrawn in view of the opposition filed by TKDL with support of TKDL. So these are some news agencies, BBC News, Times of India, and these are some of the plants, neem tree oil, melon, ashwagandha, pudina, etc. So they are traditional uses which are already known in India, and whenever such MNCs file application worldwide, they are opposed by the on the support of TKDL of CSIR and successfully revoked such applications. There are so many other cases also. So most of the times we applied successfully for such opposition and revocation. So this TKDL is accessible worldwide nowadays. Anyone can get paid subscription. So it is suggested that before filing application, people must check this database also, so that they can save their time and efforts. So these are some of the applications which are revoked. See the application number and the bioresources and the knowledge associated with that, and the utility, for which utility such resources are going to be used. So it prevents the grant of patent to inventions which are either traditional knowledge or based on the same. So TKDL helps in refusal and revocation both. So many times there are some wrong patents because in view of lack of codifications and lack of such infrastructure having such database, patent office during the examination found such applied inventions novel, new, and due to such issues, they considered such inventions patentable. So these are some of the granted patents in India. These are the patent number, bioresources used in the invention, and the knowledge associated, and these are the utilities. So surprisingly, in India, many applications in the field have been already granted. So most of the application in the field, traditional knowledge, biotechnology are abundant, grant versus. So very few are granted, irrespective of the rejection. So abandonment are very high in number as compared to granted. So lots of time, fund, and efforts are involved in patenting process, and therefore it's demotivating for the applicant and the innovator to move forward in the subject. So to conserve genetic resource, sustain utilization of this precious richness, as well as to monitor impartial benefit allotment due to it. So there are some international initiatives like CBD, Convention on Biodiversity, Nagoya Protocol, WTO, TRIPS. India took initiatives and they formulated some of the device accordingly. So there is a need for harmonized method to balance the interest of both in traditional societies and commercial entities. So in India, we have some laws like Patent Act, TKDL, GI Act, PPVFRA, Biodiversity Act. These are having authorities and under various ministries. So there are options as per the policy for fair and equitable benefit sharing. So there are monetary and non-monetary benefits. Under monetary benefits, there are access fee, upfront payments, milestone payment, payment of royalties, license fee, special fee to be paid to trust fund supporting conservation and sustainable use of biodiversity, salaries, research funding, joint venture, etc. And in non-monetary benefits, there is a sharing of research and development, research, collaborations, participation in product development, contribution in education and training. So there are some benefit sharing component as per the turnover. It may be 0.1% to 0.5%. So it can be recommended that more such sensitization program on the subject can be organized for the public for better understanding, and mutually agreed terms need to be defined for some agreements between such indigenous societies and commercial entities so that such benefit sharing can be arranged. We have one successful case story of Kani tribes where CSIR scientists got the information from Kani tribes and successfully got a patent and commercialized it, and later whatever the benefit they earn, they share with the Kani tribes. So more such case studies can be happen if public can aware about it, particularly the indigenous societies and such commercial entities. So there are some norms like for a patent in this subject, there is need of NOC from Biodiversity Authority. So until such NOC arranged to the patent office, even after acceptance of the patent, no patent will be granted. So more awareness program in the subject required. Patenting in the subject may be promoted, but with a stricter implementation of such norms, particularly prior informed consent and access and benefit sharing. Thank you.
Thank you. Thank you so much, sir. Thank you for such an enlightening session. Hope I'm audible to all.
Yes, please.
Yes, thank you so much, sir. Thank you for such an enlightening session, because this particular topic is not known to many, even though patent, trademark, copyright, many of us are aware of, but traditional knowledge is such a place which we all have to gain knowledge. So there is one question in the chat box. Sir, it is considering that IPR protects new creations and inventions, do you think codified legislation can be formulated for traditional knowledge? This is a question from one of the students.
It's not new. And that's why there is a requirement of codification of such traditional knowledge, so that if anyone try to get patent or monopolize over such traditional knowledge, such practice can be curbed with the help of such codification, so that the novelty can be devoured. Because this is the main issue. Many times we notice that such information is not well documented, not codified, and that's why wrongly such applications are granted patent.
Okay. Thank you so much, sir. Yes. So with this, we have come to the, sir, you can stop the screen share.
Sure.
Yes.
Thank you, sir. Thank you, Pankaj, sir.
Welcome.
Yeah. On behalf of Hindi Vidya Prachar Samiti College of Law, from bottom of my heart, I really thankful to all the speakers who enlighten our students through their various new facts in the field of this intellectual property protection. Like Dr. Seema, she have introduced about the biotechnological patentability and the patents of some plants and animal. Also, Dr. Variyat sir have introduced about the importance of the copyright and uses and impact of infringement. Also, he have introduced the copyrights in the digital world. Dr. Gargi Chakrabarti also very beautifully she have defined about the importance of the trademark and their secrets, the duration of the trademarks, then unfair and anti-competition concept. She have that terminology she have introduced today. And now Dr. Pankaj sir has also introduced us bioprospecting, protection to traditional knowledge and associated bioresources. Also, some unfair business practices where informed consent is necessary. So through this, sir, you have also guided our students. So very much thankful for this. Yes, thank you, Rituparna madam, also for having such a wonderful session to our students. Thank you.
Thank you so much, ma'am. I'll just give a formal vote of thanks from my part to and then we can have a group photo and then we'll end with this particular panel discussion. So with this, we have come to an end of our today's panel discussion on intellectual property protection in the changing era. It has been a wonderful, informative session. We definitely all have learned a lot and have got enlightened on this particular topic, which is very relevant at today's time, that is intellectual property right. For this, I first and foremost must thank our respected dignitaries for today's event. That is Dr. Professor Anil Variyat sir, Dr. Seema Sambarni ma'am, Dr. Gargi Chakrabarti ma'am, and Dr. Pankaj Kumar sir. Thank you for accepting the invitation. I'm saying this again and again because it was too early in the morning. Still, all have taken out time and given us this opportunity to hear from all of you. Also, in absentia, I would say my heartfelt thanks to the president of HVPS, that is Hindi Vidya Prachar Samiti, Dr. Rajendra Singh sir, the director of Hindi Vidya Prachar Samiti, Dr. Usha Mukundan ma'am, our very own principal ma'am, who has always guided us and given us the best suggestion. And because of her only, we get the motivation to do such kind of programs. So Dr. Madhura Kalamkar ma'am, our IQAC cell coordinator, Dr. Amar Salve sir, and all my other colleagues, faculty colleagues, and my students, definitely the student council members who have helped me in conducting this program. Thank you all. I'll just request all the participants and speakers for whom it is possible to switch on their camera so that I can take a group photo. And also, I will request all to fill up this feedback form in order to get the e-certificates. So all the participants, speakers, all those who are present, kindly switch on your video. Thank you. Just a minute. Thank you. Thank you all. Thank you, sir. Thank you all. I think we can all leave the meeting for now.